For law students, constitutional law is different from the kind of thing you study in contracts or in torts or in civil procedures. When I teach constitutional law, I'm teaching it to people in the spring term of their first year. And unfortunately, they think of law itself as inherently the kind of thing that gets done the way Justice Cardozo would do these contracts opinions, or Justice Holmes would do these torts opinions. So you look at the particular facts and you look at the situation, you get really good at drawing analogies to other fact situations, and you sort of just make up the right rules. Sometimes you take the same rule as an earlier case, but more or less you're reasoning from case to case. Constitutional law is not like that. Constitutional law is the interpretation of a particular document, the Constitution, that expresses things at a particular point in time. It's not a common law subject that's evolutionary, where judges, really their mandate as judges, doing tort law, doing contract law, is to come up with the best decision in light of all the precedent they've had before. Constitutional law is an interpretive enterprise. It might be other things as well, but it is at least partly an interpretive exercise, and law students need to know that so they can understand the difference between constitutional law and their other law school classes. The way I teach constitutional law is a little bit different from how some other folks teach it. The guiding metaphor I use is military history. So it's a series of intellectual battles that get fought. Some of the intellectual battles that you study in constitutional law are battles that don't look terribly likely to get repeated anytime soon. But learning those battles is important for a very similar reason that it's important to understand just how it was that Alexander the Great conquered the Persians. Understanding what happened in Lochner, for instance, even though since 1937, Lochner has been an opinion of very low prestige. Understanding what happened in Dred Scott, even though Dred Scott has been overruled by the 14th Amendment. Those intellectual battles are extraordinarily important for current law because similar battles get fought today, and because the Constitution we have is the Constitution it is because of the way in which it reacted to those earlier battles. So I always say, you don't just want to learn the boundaries of the current map of Europe. You don't just want to know who owns Alsace-Lorraine. France owns Alsace-Lorraine. Knowing that is akin to knowing just the rule that got established in the case that just got decided last June. But understanding what happened in those arguments, how those arguments clashed with each other, how it produced those boundaries. So what happened in the Napoleonic Wars? What happened in the Franco-Prussian War? What happened in the First World War and the Second World War? Knowing all of those things that explain ultimately why France has Alsace-Lorraine today, that's akin to knowing what happened in Dred Scott and the Slaughterhouse cases, and Munn and Lochner and Wolfe and West Coast Hotel, all these earlier cases, even though the doctrinal statement might be very, very simple. Don't be misled by the simplicity of the doctrinal statement that you need to know in order to pass the bar exam. Knowing bar exam constitutional law is not the same as understanding constitutional law. It is not the same as the thing you need to know in order to fight tomorrow's battles about the Constitution.